And finally, I mean, considering the times that we're in, you know,
Mhm.
the pandemic and the coronavirus, it would just be useful to hear your take on the interaction between redundancy and the current situation. Is there anything that people need to be aware of in particular based on the unique circumstances that we find ourselves in?
I mean, one of the problems with the law is it relies a lot on cases to be
Mm,
brought and won or lost. And obviously, no coronavirus case has been brought and won at a
mm,
final hearing yet, as far as I'm aware, anyway. Because even before the backlog that the virus caused,
mm,
there was already a backlog. You were already getting cases listed in January for December.
sure.
The permanent secretary at the Home Office who resigned in February, his claim is in December, so that was before the virus. So um, you already so it's made. I would say it's probably made bringing a claim less attractive
Mm,
because of the wait.
mm,
And like I said, with big employers, and I don't want to speak generically about all big employers are good employers because they're not, but the bigger an employer is, the more likely they are, if only because the reputational damage of being a shoddy employer is not good.
of course.
So that it's not good for their share price. Um, they will normally do a relatively good process. You might not like it, but they'll do a relatively good process. But for smaller employers who either don't know the rules
Mm,
or are just not very nice employers, um, they will. It will certainly be the case that some employers will go, well, this person is going to bring a claim, but they're going to have to wait 18 months
mm,
before it gets heard, or a year before it gets heard, and I'll deal with that problem in 18 months.
mm,
Or they might rely on you not bringing a claim because that wait is so long. Or, and this is something we obviously know about, that it's because there's the big factor with redundancy is that it now exists, right? There are all, I don't think any of the redundancy cases that we've advised on in the last 2 months or so, because as the furlough scheme comes to an end, that's what's biting.
yeah.
Um, I don't think any of them have not been COVID related, or at
Mm,
least the employer hasn't blamed COVID on it. I
mm,
mean, maybe there were one or two where the employer's taking the example chance to cut some fat. But generally speaking, like all of the redundancies that are going on at the moment are more or less are going to be because of COVID.
sure.
Um, so in terms of that, yes. So there's a factor that employers might take advantage of that.
Mm,
Um, there's and again, this feeds into what I was saying about disability and reasonable adjustments, not just to the selection process, but to your work.
mhm,
It might be that working from home means that certain types of employees are less necessary. So, for example, if you've got a facilities manager and like 3 deputy facilities managers, but actually now your office is only being used by 5 people 3 days a week instead of 100 people 5 days a week,
mm,
that might mean that a role that probably wouldn't have been in danger is specifically in danger because of the virus, because people are working from home more. But it also means that you might be up for redundancy in a scenario where um, working from home is harder.
mm,
So the job just can't be done from home, but the employer needs it to be done from home because their facilities are too small or not safe for some other reason. Um, so it may well be that the virus makes you because you need to work from home for some other reason more likely to be selected for redundancy than
mhm,
if a redundancy process is being carried out while you're all in the office.
sure.
So it will affect the circumstances. It will probably mean, this is speculating, it may well mean that how the tribunal assesses the reasonableness or the fairness of the process itself
Mm,
might change. They might give a bit more leave. So with the reasonable, uh, you know, is the dismissal a decision no reasonable employer could take in the circumstances? Is the test from fair dismissal? Well, in the circumstances is the key phrase there, because it's always was it reasonable for the employer in the circumstances it was in, knowing what it knew at the time or could reasonably be expected to know the factors it did. Now, obviously, it's a lot easier to run an inclusive consultation process if everyone is in the office. So it may be that what an objectively fair process will look like will change as a consequence of how we're working changing.